Hello and welcome to our discussion on business interruption loss and COVID-19 claims. We are so sorry that we can't be with you in a nice ballroom with good food and fancy drinks, but we are grateful that you've joined us virtually. We're going to start off the discussion by looking at the ABCs of what these claims are all about, and I'll hand that over to you, Sonia.
Thanks, Shanti. So that's right. I mean, as we all know, many businesses have suspended operations as a result of COVID. And I believe that there are going to be a lot of claims that are going to turn to their insurers to look for coverage. What I think a lot of claimants might not understand, however, is that business interruption coverage is actually a function of commercial property insurance. And historically, commercial property insurance provides coverage for damage to property, physical damage to property. And there are two means by which these policies are structured. One is an all risks policy. So that type of a policy insures businesses against any kind of fortuitous risk, save the exceptions. So sort of the coverage is very broad, and claimants might therefore think that they have coverage for COVID-related losses. But what's interesting about all-risk policies is that particularly since 2003 and the SARS epidemic, insurers have started including exclusions for infectious and communicable diseases. So while claimants might ultimately be very excited about the fact that there's this all risks policy that they presume applies to their business interruption, insurers can obviously turn to the exclusions to deny coverage. And while we don't know very much yet about how those exclusions are going to be interpreted, there is a sense that the language used to communicate those exclusions will matter, as language always really matters in coverage. So, for example, we've read policies that talk about exclusions for microorganisms, damages caused by microorganism or by virus. And that type of language is very strong because it's very applicable to COVID. So we anticipate that well-worded exclusions will suffice to exclude coverage under these all-risks policies. The second type of policy is a specific peril policy. So that's kind of the inverse. And the idea is that, rather than covering all kinds of damages that might occur to a business property, you specify exactly which ones are covered. And so, you'd assume that since SARS, very few policies actually include specific coverages for microorganisms, for virus, for communicable disease. And to some extent that is true. However, we've actually seen in our firm at least one instance where under a specific peril policy, microorganisms, infectious disease were specifically covered. And so that does present the idea that there can be coverage in these situations, hypothetically.
So the second challenge we anticipate insurers will face is the issue of proving the presence of COVID on the premises. So even in cases where infectious diseases is clearly covered under the policy as a named peril, the policies may still require, depending on the wording, that the insured prove that the business losses were a result of the actual presence of COVID on the premises or within a certain radius of the premises, and not just a result of the threat or the suspected presence of COVID. Because of that, for those businesses that close down because of due to a government order or voluntarily, to avoid an outbreak of COVID on their premises, coverage may not be available for them. So we've already seen in Ontario as well as globally that litigation has arisen where insurers have taken this position. And the final issue that we anticipate insurers will have is the issue of waiting period deductibles. So business interruption coverage is only intended to cover the period of time it takes for an insured to restore the premises to the pre-loss condition, and usually includes a 1 or 2 week waiting period deductible. So for businesses that have closed operations or suspended operations because of the presence of COVID, in practice, the time it takes for them to sanitize their property may not be that long. So if that's the case, the eligible business losses may not surpass the deductible, or if they do, they may not surpass it by very much. And I know, Matt, you've been looking into some case law on this issue.
There haven't been any Canadian decisions yet, but there's been several in the U.S., and if the U.S. decisions are any indication, plaintiffs are going to run into a lot of problems in trying to bring losses as a result of COVID under their business interruption provisions of their policy. And plaintiffs seem to have taken two separate approaches in trying to prove these claims. And the first is to argue that the government order itself has resulted in a direct physical loss of the property. And the barriers they're facing with that approach is that a direct physical loss, courts are saying, requires something tangible, some sort of material alteration to the physical property that's insured. And a government order, of course, although it does prevent access to the property in some cases, just doesn't create any material alteration. It's incorporeal, it's intangible. And so in several cases that have brought this up, it's failed objectively. In one case, a judge called the argument nonsense. The other approach that plaintiffs seem to be taking is to argue that the presence of a virus that permeates the air, that is all present and causes widespread community panic and danger, is physical damage, that the virus lands on surfaces. And when it lands on surfaces, it renders that surface dangerous and unusable. The problem that, in doing so, they try to draw analogies with cases that have had some success in some jurisdictions in the U.S. That have allowed claims where, for example, there's been noxious odors or dangerous chemicals that have permeated the property but not caused physical damage to the property itself. And plaintiffs are running into two difficulties with that approach. The first is evidentiary, proving that COVID actually or literally is in the property at the time of the shutdown is going to be very difficult. But it did lead to one funny case where the judge asked how the plaintiff intended to prove that there was COVID on the property, and the lawyer said, well, the business owner's here and he has COVID now. But more seriously, a problem that plaintiffs are running into in these cases is whether the physical damage caused the business losses. So even if the court accepts that there was COVID on the property at that time, in these cases, the businesses aren't alleging that they shut down because there is COVID on the property. They're alleging they had to shut down because the government ordered it. And the government order, as we just talked about, isn't physical damage. So physical damage is not causing the business losses, and it's not constituting business interruption losses.